In his book, Building the Judiciary, Professor Justin Crowe provides an in-depth historical analysis of how the federal judiciary moved from political irrelevance to becoming one of the strongest institutions of government today. It is important to remember that the American judiciary has very humble beginnings. For example, in 1790, when the United States Supreme Court first convened, the court did not have even one single case to hear. The court of the late 18th century lacked prestige, it lacked respect, and it lacked power. It had no building and only a very small budget. The court during this time was also largely controlled by both the executive and legislative branches of government. During the next few weeks, we will examine how the American court system, and specifically the U.S. Supreme Court, has become independent and autonomous. This has been a long road, and it certainly did not happen overnight. If you look at the Constitution of the United States, you will see that Article 3 discusses the judiciary. Article 3 is very succinct, and it accounts for less than 1/10 of the Constitution. It mentions that judicial power will be vested in one Supreme Court. However, Article 3 gives no indication of how many individuals will compose the Supreme Court. While we know that the founding fathers of this country wanted a judicial branch of government, they clearly did not provide explicit instructions as to how the American judiciary should grow. As we will see throughout the book, judicial institution building has occurred from transformative moments, often initiated by political actors seeking to reallocate power. During the early days of the American judiciary, there were numerous obstacles that inhibited the building of the judiciary. We will analyze these obstacles and examine the manner by which the judiciary has become much more independent and autonomous today than it was in the beginning. For the purposes of this lecture, I will focus primarily on the establishment of the American judiciary from the beginning of George Washington's first term as president in 1789 to the end of Thomas Jefferson's first term as president in 1805. This period of time has been referred to by many historians as the early republic. Keep in mind that in 1789, Americans were tinkering with this newly found experiment of constitutional democracy. The United States was trying to jumpstart its economy, and it was raising revenue for its military defense. Also, the newly found country was trying to avoid another war with England. Many Americans in 1789 were reluctant to vest broad powers in judges who were unelected officials. During the new republic, there were essentially two competing political parties. First, there were the Federalists, also referred to as Nationalists. Alexander Hamilton, our first Secretary of State, was more or less the intellectual leader of the Federalists. Federalists encouraged a strong commercial economy and a strong centralized government. Federalists believed that national courts needed to resolve interstate disputes over trade and maritime commerce. They worried that the lack of dependable laws, coupled with the weak federal judiciary, would paralyze economic development. The competing political party during the early republic was known as the Anti-Federalists. The Anti-Federalists, who tended to be agricultural localists, were very leery of a strong federal government, and they were also reluctant to have a strong federal judiciary. The Anti-Federalists also had an aversion to the notion of a highly centralized Supreme Court because they feared that this would undermine the jury system and impinge upon states' rights. They preferred to utilize state courts for most judicial business, limiting federal jurisdiction to a small subset of cases which were not believed to impinge upon states' rights. In 1789, the United States Congress would meet. By the time it met, it was clear that there was great concern about the judicial branch. Anti-Federalists wanted to limit the power of the judiciary. They were especially concerned by the fact that state and local interests were not being represented in the judiciary. It was a Connecticut senator by the name of Oliver Ellsworth who fashioned a piece of legislation which was a compromise between the Federalists and the Anti-Federalists. Ellsworth, who was regarded as a moderate Federalist, was the main architect of a statute that would be known as the Judiciary Act of 1789. Even though Ellsworth was a moderate nationalist, he was still sensitive to state interests. He would establish a federal district in each state. This way, the new system would not drag citizens away to courts far from their homes and families. Also, Ellsworth's plan required Supreme Court justices to ride circuit. This meant that justices were required to travel throughout the nation and join district court judges in hearing cases among the lower courts. Circuit riding was designed to unify the court system as well as guarantee a high level of interaction between the Supreme Court justices and district judges. The Judiciary Act of 1789 also gave the Supreme Court appellate jurisdiction over all classes of cases, from lower federal courts to state courts. Also, the Act set the number of Supreme Court justices at 6, 1 Chief Justice and 5 Associate Justices. In some respects, the Judiciary Act of 1789 limited federal jurisdiction in certain types of cases. But again, remember, this act was considered to be a compromise. In order to get the act through the legislature, Ellsworth had to make concessions to the Anti-Federalists who simply did not trust a strong centralized government. And his plan worked. The statute passed the Senate and House and was signed into law by President George Washington on September 24, 1789. Let us consider how Oliver Ellsworth was able to get the Judiciary Act of 1789 through the legislature and passed into law. First of all, Ellsworth demonstrated a willingness to incorporate opposing viewpoints. The Judiciary Act of 1789 was not as powerful as the nationalists had hoped, but more powerful than the localists had feared. Neither side was 100% satisfied with the act. However, history has shown that the Judiciary Act of 1789 established the foundational pieces of what would become a powerful judiciary. Also, the court's rulings throughout the 1790s were closer to nationalist principles than to localist ones. President John Adams, the second American president, would also begin to make partisan judiciary appointments. Adams was a member of the Federalist Party. Therefore, he appointed judges who favored a strong centralized government. This upset politicians such as Thomas Jefferson, and support for the judiciary began to dissolve, particularly among anti-federalists, who by this point in time would be known as Democrat Republicans. Under the leadership of Thomas Jefferson, who would soon be the third president of the United States, Democrat Republicans aimed to dismantle the the strong national government, which included the federal judiciary. Once Federalists realized that John Adams would lose the presidential election to Thomas Jefferson, the outgoing president authorized the appointments of federal judges, also referred to by historians as midnight judges. Adams stayed up late into the night in the waning days of his administration signing these midnight appointments. And, as we shall soon see, these appointments would give rise to the landmark case Marbury v. Madison, which would establish judicial review. After winning the presidential election and taking the oath of office, Thomas Jefferson ordered his State Department not to deliver the commissions that Adams appointees. One of the midnight judges by the name of William Marbury sued, asking the Supreme Court to grant him his judgeship. The legal questions in this landmark case were simple. First, did Marbury have a right to his commission? And, if so, did the Supreme Court have the power to make the president grant this judgeship? The Chief Justice of the Supreme Court, John Marshall, was very clever, and in an act of judicial jujitsu, he and the other Supreme Court justices unanimously ruled that Marbury had a right to his commission, but the court could not force this commission to come to fruition. In his opinion, the court ruled that federal statutes which authorized the court to issue orders of this kind were unconstitutional. Consider for a moment the confusion that must have occurred among President Jefferson and his party as a result of this case. They could hardly object to the outcome of the case, since Chief Justice Marshall had given them what they wanted in the short term: no commission for Marbury or any of the other midnight judges. By boldly and unequivocally asserting the power of judicial review, the power of federal courts to strike down laws that clashed with the Constitution, Chief Justice Marshall and his colleagues on the court strengthened the power of the federal judiciary over the long term in ways that his opponents at the time could hardly imagine. Had Chief Justice Marshall and his colleagues ordered the White House to deliver Marbury's commission, President Jefferson would most likely have simply ignored this order, which would have undoubtedly weakened the judiciary. Instead, through this important decision, the court was able to preserve and eventually gain a significant amount of power.